This is a very important topic. Obviously, privacy is on a lot of people's minds. I'm thrilled to have Alan here today. We're both a little rough around the edges, Isabel, you mentioned that, but that's probably why we get along so well. So I'm really pleased to have him here. He's an internet law specialist. He'll answer all your questions regarding Law 25. It's a big topic. We're going to cover a lot of things today. But there's a lot of participation today, which is great. Obviously, there's a lot of companies that this impacts, not only in Quebec, but around the world. If you're doing business with people in Quebec, you need to keep your ears open here and ask the right questions. So feel free. At the end, Isabel will be fielding questions. If we don't get time to answer everyone, obviously, both our contacts will be available. There will also be a recording available to everyone who signed up, and we'll make that available to everyone. So without any further ado, I'll let Alan take the floor, and I'll jump in if I have to and when.
Thanks so much, Kevin. It's a pleasure to be here. I'd like to thank everyone out there for coming today. I'd like to thank Cake Mail for the invitation. Kevin in particular, et aussi à Isabelle, merci beaucoup pour tout ce que vous avez fait. L'organisation, c'était excellent. Very pleased to be here today. I will make the slides available to anyone who wants them afterwards. We'll figure out a way to take care of that. So don't worry if you're worried about taking notes or anything. I'm happy to make my slides available. And as mentioned, please ask me any questions dans deux langues. Ça me dérange pas de vous répondre en français certainement at the end. So, as Kevin mentioned, I'm an internet law specialist, and people tend to wonder what that is and how I came to be as an internet law specialist. This is my business card in front of you. And as I like to joke, it sure looks like I have a lot of degrees, but in fact, there's one missing there. So they're actually not all on there. It's a great story how I became an internet law specialist, but in an hour-long presentation, I just don't have the time. And you didn't come to hear my life story. Suffice to say, I spent time both as vice president of a web technology company and as a lawyer, and I sort of put all of those together. And so for the past 14 years, I've had my own practice in internet law. And internet law, as you can see in front of you, people don't even know what that is. And as I like to say, there is no internet law, capital I, capital L, but everything is internet law, lowercase I, lowercase l, meaning I deal with all sorts of issues, including intellectual property and contracts. And of course, as my good friends at Cake Mail are all too aware, specific internet laws like the Canadian anti-spam legislation or CASL. I deal with that all the time. And of course, top of mind on the internet is privacy. And that's why we're all here today. And believe me, I have an expertise in privacy, I promise you. And one final note, as you can perhaps see behind me, that's the McGill's Faculty of Law, where I've been teaching internet law for the last 7 years. And you can certainly bet that privacy law plays an important part in my internet law course at McGill. So let's, just to make sure we're all on the same page and you guys know what's coming here, let's just sort of take a step back and take how we got from Bill 64 to Law 25. And I apologize. I expect that there is a wide variety of knowledge out there, but this is a business crowd, and in case you don't have the basics sort of how laws work, I just want to make sure that we all understand why something that was once called Bill 64 is now called Law 25. Well, as some of you may remember, the very famous Saturday morning cartoon series, Schoolhouse Rock, there was one called How Bill Becomes a Law. You have to be a certain age to remember that series. I think Kevin and I are, but the rest of you maybe not. And anyway, so the government introduces a bill, and once the bill is voted on, it becomes a law. It's relatively as simple as that. So about 4 years ago, the Quebec government introduced Bill 64. I would see the actual title of Bill 64 in front of you. And what's important to note about Bill 64 is that it does not create any new law in and of itself. It simply amends the existing law, the Act Respecting the Protection of Personal Information in the Private Sector, which I tend to call the Private Sector Act. You know, everyone has different ways of referring to it as a sort of a shorter name. But if you hear me say the Quebec Privacy Act or the Private Sector Act, that's what I'm referring to. And that's what we're going over today. All of the changes that Bill 64 made to the Private Sector Act. Now compare that to the federal Bill C-27, which in and of itself does the same thing sort of as Bill 64. It reforms privacy law at the federal level, but it creates new laws. As you can see in the title of the federal bill, it creates the Consumer Privacy Protection Act and a couple of other acts as well. But we're dealing today with Bill 64, Law 25, which I want you to remember does not create any new laws, just amends the existing one. But boy, does it amend it. And we'll be going over those big amendments today. So, you know, a few interesting facts about Law 25. So Law 25, Bill 6, as I mentioned, Bill 64 became Law 25 with the official numbering system of LQ, which stands for Lois Quebec, Laws of Quebec 2021, Chapter 25. So that's why we call it Law 25. And we now have this name of a law. While today we're going to be talking about how it amends the Quebec Privacy Act, in fact, Law 25 amends 21 different laws. There is also a Quebec Privacy Act that applies not to private organizations, but applies to the Quebec government and government organizations. And that's the other big privacy law in this province. And that one is also amended by Law 25 or Bill 64, just so you know. So it finally passed on September 21st, 2021, and I will talk shortly about how it comes into effect in stages. And an interesting thing to note is that, you know, it was passed unanimously, not a single vote against. Everyone thought this was a good idea. While everyone in the legislature thought it was a good idea, those of us who have to abide by it and those of us business people, like our crowd today, they may not be so happy about it, but it is what it is. Now, another sort of introductory note that I think is very important to discuss, and there is a bit of a complicated issue legally. I expect many of you out there have heard of PIPEDA, the Personal Information Protection and Electronic Documents Act, which is the federal privacy law. And the federal privacy law that theoretically should apply because it's a privacy law all across Canada. But Quebec also has a privacy law. Well, wasn't the Constitution supposed to sort those things out? It was in fact, Canada's original Constitution, the BNA Act of 1867, says very specifically that federal government has certain powers to enact laws, and provincial governments have certain powers to enact laws in specific areas. Unfortunately, privacy happens to fall into both spheres. So legally or constitutionally, the federal government can pass privacy laws and provincial governments can pass privacy laws. So you get a complicated situation because the federal privacy authorities have determined that Quebec, Alberta, and British Columbia have provincial laws. So if you're operating in the province of Quebec, those provincial laws will apply. But everywhere else in Canada, the federal law applies. Now, the most important problematic aspect of that is, and perhaps you've figured it out by now, what if you are an Ontario company that collects personal information from Quebecers? What if you are a Quebec company that collects personal information from people in Toronto? Well, which law applies? unfortunately, that is a topic that I could talk for an hour on. Suffice it to say, there is mass confusion. And suffice it to say that the Commission de l'accès à l'information, which is the Quebec body that oversees privacy law, the Quebec Privacy Act, they say that if you're a Quebec company collecting information from Toronto, the Quebec Act applies. If the other way around, the Privacy Commissioner, the Office of the Privacy Commissioner is the federal office that oversees PPADA, they say the opposite. They say that PPADA should apply. So what's a poor business owner like you to do? Well, the good thing is if you can adhere to the terms of the Quebec privacy law, I promise you, you will also be adhering to the contents of PPADA, the federal law. Now, if you look at the actual law itself, it doesn't really say specifically whether, as a Quebec company, if you are doing certain things outside of the province, you are supposed to adhere to the Quebec law. Okay? The only real definition in there, the bolded word that I have, is an enterprise, and that's a definition that comes from another Quebec law, the Civil Code of Quebec, and that just means any company, basically. Okay? And as I mentioned, the Commission de l'accès à l'information takes a very broad view of that. If you're an enterprise, and if you're collecting personal information from anyone in Quebec, even if you're doing it from outside of Quebec, the Quebec law applies to you. So if any of you out there are outside of this province and you think you're going to get away with just adhering to PPADA, which as of this moment is very easy to adhere to, if you're collecting personal information from Quebecers, by the way, it's a side note, it strikes me that I forgot to introduce this topic at the very beginning. I keep using the term personal information, and you may have noticed the title of my slide today, for good reason. Cake Mail has talked about how this is a conference for email marketers, understandably considering what Cake Mail does for a living. And all of you out there, I'm sure, are email marketers. I'm giving this lecture sort of a basic, introduction to Law 25. But every time I mention personal information, I want you, all of you out there, all of you email marketers, to put in your head email addresses, because guaranteed you're sitting on tons of email addresses because you're an email marketer. So therefore, that's personal information, and I want you to think about that while we go through it. So just that's what I'm saying, is that if you are a Quebec company and you have the email address of a person from Toronto, or if you're a Toronto company and you have the email address of someone in Montreal, well, according to the Commission de l'accès à l'information, you are in fact responsible to be adhering to the Quebec law. Now, again, there's nothing specific about application, but there's a new section 17 that requires you to do what's called a privacy impact assessment. I'll talk a little bit more about those later, although just so we're clear, in the law, in the English version, it's called an assessment of privacy related factors. But everyone in our industry, my industry, the legal industry, the privacy industry, calls them privacy impact assessments. Okay. So there's a new law that says, there's a new part of the Quebec privacy law that says, well, as soon as you send information outside of Quebec, you have to do a PIA. Well, as soon as you send information outside of Quebec, now we're in both situations that I have mentioned. We're talking about the Toronto company that collects an email address from a Montrealer, and we're talking about a Montrealer that collects it that gets it from outside. So it would seem that, well, anytime you do something with a personal information, with an email address, send it outside of the province, receive it from outside of the province, you have to do a PIA. So it would seem that sort of by implication, the law is saying, wherever you are in Canada, if you're somehow connected to Quebec, you should be adhering to Law 25. All right, you've had enough of my babbling, of my introductory remarks. It's time to
Alan,
get to, yeah,
I
go
don't
ahead,
want to
Kevin.
interject here. Just, a lot of our audience might be wondering, is it just the email address? I mean, being within Cake Mail, I, have some experience with personal information and what our clients use, with regard to their lists. I mean, what they choose to upload into our product is completely up to them. But I mean, personal information doesn't stop at an email address. It could be, their first or last name. When we do, link tracking or open tracking, after we send our clients send out campaigns, we actually record the IP address of that particular person. And, that can be used for geolocation, for example. So, I mean, all of this can be considered
Absolutely,
PII.
Kevin. Kevin,
It doesn't, it's not limited to just the
No,
email
no,
address.
absolutely, Kevin. That is, excuse me, a very good point. And my apologies for not properly
fine.
introducing what I mean by personal information. So let's take a step back. Personal information is, and I can almost quote the definitions that come out of the laws verbatim. Personal information is any information that can be used to identify an individual or used in combination with other information to identify an individual. So, and I stress that second part because I'll explain why in a second. That first part is kind of obvious. Someone's email address, someone's name, someone's address, someone's telephone number, someone's social insurance number, someone's credit card number,
very broad.
etc. Okay. Though all of those things are very easy to define as personal information because they identify a person. They are a unique number, address, piece of information that identifies an individual. The second part is perhaps a bit more complicated. And Kevin, you mentioned IP address, and that's a good one. So an IP address in and of itself can't identify an individual. However, if I take an IP address and I use a technical means to do a reverse search to find out that IP address was assigned to Videotron or any other internet service provider, I can find out from that internet service provider who was using that particular IP address at any time. So by definition, an IP address, while not directly able to identify, in combination with other information, can be used to identify an individual. And that goes the same for any other alphanumeric string that you may drop onto an individual's computer or device. All sorts of tracking systems that go on. Facebook drops a pixel. I apologize for those who are not technically inclined and don't know what I'm talking about, but many of you I'm sure do. Facebook drops a unique pixel onto an individual's device. That pixel can be tracked back to a Facebook account, meaning it can be tracked back to an individual. So that pixel in and of itself is personal information. So thanks for that. That was good sidebar, Kevin. I appreciate it. So let's get to the meat. And I will apologize perhaps a bit in advance here. I'm gonna throw a lot of the text of Law 25 at you. Now, of course, remember, I'm actually not throwing the text of Law 25. I'm throwing the text of the Quebec Privacy Act as amended by Law 25. And some of it is pretty complicated legal language, but I'm here to do my best to simplify it and to make it somewhat more understandable. And, one of the problems we have with Law 25, and I'll just a little editorial side note here, is that, and one of the reason why you're going to see a bunch of actual text from the law is that there's very little guidance so far. And I give a very specific example of that later on in this presentation. A bunch of people have written about it. I've written about it. Lawyers have written about it. But we're all mostly going off of the text. So we have to interpret the text ourselves because the Commission de l'Accès à l'Information has not done a very good job, in my opinion, interpreting some of these texts for us. So there is a lot of guessing. And that, is a spoiler alert for our question and answer period later. There's going to be a lot of questions. I'm going to say, you got me. Anyway, we'll get to those later. So as I mentioned, the law came into force. The actual law came into being. So into force means just came into existence September 21st, 2021. And it said that a bunch of the things would be happening in stages. So last year, September, a few things came into force. This coming September, a whole bunch of things most of it, frankly, is coming into force. And 2 years, well, 1 year from this September, there's just like one important thing left. So let's take those, excuse me, chronologically.
Alan, I imagine that was done by design. I mean, there's quite a lot to this bill, and having everything done at once would be a mountain of work for a lot of people. So rolling it out over stages, as well with the government. I mean, they have time now, obviously, to release these guidelines.
Absolutely. I wish they would have put a few of the things that are coming up this September off to the next year. But certainly, to follow from what you just said, Kevin, what they've done, the important things that came into effect in September of last year are very easy to conform to, right? So what we have here, the only actual positive duty that came into effect is that a corporation should appoint a privacy officer, okay? But even at that, even if they don't appoint a privacy officer, well, they don't get penalized for it, because according to the law, the person exercising the highest authority, the CEO generally, would be the privacy officer by default. So all of these things in front of us, there was nothing to do. So so appointment of a privacy officer came into effect last September. You're supposed to publish information about them on your website, and they are ultimately responsible for all the privacy regulations and laws in the organization. So for those of you out there who have not yet named a privacy officer and put that information on your website, you should go ahead and do that, because otherwise the CEO is going to be responsible for it. The privacy officer can be anybody, does not need to be a lawyer, doesn't even have to be someone within your organization. So, but make sure you have that information on your website.
Alan, correct me if I'm wrong, but I believe that's a distinction with the GDPR in Europe, in that the CEO by default in Quebec with the privacy law is by default the TPO.
Correct.
I'm not sure that, yeah. So that's
correct, exactly. So
I mean,
so also, the mandatory data breach reporting, if you have a data breach at your company, you have to now report it when there is a risk of serious injury to the individuals who are a victim of the data breach. That's only a positive obligation when a data breach happens to you. So that's very good. And easy to adhere to if that ever comes to being. The data breach reporting is actually one of the few things Quebec is catching up to Canada on. Canada under PPEDA has had mandatory data breach reporting since 2015. And they have roughly the same. The RROSH that you see on the screen is real risk of significant harm. That's the standard for determining whether to report a data breach under PPEDA. And it's roughly the same, even though they're called risk of serious injury under the Quebec law. And, important forever in Quebec, if you were selling your business and you were transferring a whole bunch of personal information to the company buying your business, in theory, you had to get permission from each of the individuals who you held personal information from to transfer to the new owner. Or even in the discussions in the negotiation, if the potential buyer wanted to see your database of customers, well, a database of customers is personal information, contains names and addresses and email addresses, presumably. You couldn't do that without permission of the individuals involved. Now that exception, the exception for commercial transactions, means you can. So those were the main things that came into effect last year. All right, so let's get into it. What comes into effect this September? So you need to have policies and practice regarding personal information. Every time you see PI on your screen, that's personal information. Now, that's not necessarily just a privacy policy. That includes a privacy policy, certainly. But do you have a procedure as when and how you're going to destroy personal information? Who is responsible for personal information in your organization? If someone, an individual, complains to you, do you have some sort of procedure for that? All of those need to be documented by September of this year. Now, many of you probably have things like that because in some ways they're technical documents as well, but many of you might not. Interestingly enough, the first draft of Bill 64 said that you had to actually publish those procedures and policies on your website. The final version of the draft didn't say that. It said you just have to publish information about that. What does that mean? I have no idea. Again, it's one of those things that we're going to see throughout this presentation that we have no guidance. We only know exactly what it says in the law. And as I mentioned earlier, when talking about the when information leaves Quebec or information goes back and forth across the Quebec border, you have to do a privacy impact assessment, which technically in the law is called an assessment of the privacy related factors. Okay. So anytime you do something with an information system, create some new database or some new product that involves collecting, using, communication means transferring. It's a bad translation from the French. Anytime you put some new system in place, you have to do a privacy impact assessment, as well as anytime you send data outside of the personal information, outside of the province, you have to do a privacy impact assessment. How do you do a privacy impact assessment? Again, I have no idea. The Commission d'accès à l'information, as mentioned, the Quebec body responsible for overseeing Law 25, has a guide on its website for doing privacy impact assessments. But there's a big message on the face of that, on the cover of that guide that I've cut and pasted in front of you, saying very specifically, the guide it covers the law, the Quebec Privacy Act, as it existed before it was modified by Law 25. We're getting to review it. We're going to revise it soon. I have been staring at that message for a year. Just checked it again yesterday. You're not helping me, Commission d'accès à l'information. I've got clients asking me, how do I do these? And I don't know. So they've got 130 days left. They better get to work. All right, so moving on. What else have we got coming into effect in September of this year? It's very clear that you have to inform individuals that you are collecting, well, a whole bunch of things that you have to inform them. And now you have to inform them in clear and simple language, or as I like to jokingly refer to it, especially with people who understand this reference, CASL. Okay? And The clear and simple language basically means that you probably have to redraft your privacy policies, because your privacy policies were probably written by a lawyer like me, who wrote it 5 years ago, 10 years ago, when we used a lot of legal speak in our privacy policies. Now, some of you maybe have privacy policies that are GDPR compliant, and those tend to be in much friendlier, clear, and simple language. So that's going to be, I would say, the biggest challenge for organizations between now and September. Getting their privacy policies done properly so that they are easier to read. Because remember, these are not supposed to be read by lawyers. These are supposed to be read by individuals who you are collecting their personal information from. Okay? And there's a bunch of requirements very specifically. By the way, every time you see a number in here, the 8, the 8.1 and 8.2, those are just section references to the amended Quebec Privacy Act. Well, and all the details you have to put in there are enumerated in your privacy policy, are enumerated in these sections. That 8.1 note is it's a little bit complicated, and it's generally about if you're using various tracking technologies on your website. Okay, you have to be very clear to people that you are doing that. Okay, and how they keep going back and forth whether to deactivate those processes or activate it. Right now, the law actually says activate, which would mean that if you wanted to use that Facebook pixel I mentioned earlier, in theory, you have to get permission from the user first. 8.2, again, if you ask me, it's just a repeat of what's in 8. Okay, you have to draft your privacy policy. It's called a confidentiality policy in the law. Again, I'm using the term from the English version of the Quebec Privacy Act, which is my opinion is a bad translation. Politique de confidentialité, which I use tout le temps en français, c'est terme correct en français, ou politique de vie privée, but no one calls it a confidentiality policy in English. It's a privacy policy in English. Another thing that comes into effect in September is the concept of privacy by default. This is a concept that comes from the GDPR, where privacy should take precedence over everything. Safety of personal information should be what you think about all the time. Anytime you introduce a new product, anytime you introduce a new service, how is this going to affect privacy, personal information? And you've got to have the highest level possible under the GDPR. Everyone has to do that. Under the Quebec law, only those offering a technological product or service. So probably, again, do I know what they mean by technological product or service? I do not. But if you can interpret it very broadly, basically means any activity that happens over the internet certainly is going to fit into that. So remember, we are now sort of, increasing the level of privacy protection required under this law.
I think a lot of the people out there have clients in Europe, and they went through this practice a couple of years ago for the GDPR. And would it be fair to say that they have an advantage in this case? They've done a lot of the groundwork already, getting ready for GDPR with regard.
They have an absolute huge advantage, Kevin. That's a very good point. Anyone out there who has done a bunch of GDPR things already, who says that they are compliant with the GDPR, most likely will be in compliance with all of these things that come into force. Now, there are a couple of little differences. There are a couple of little tweaks that are not necessarily the same as in GDPR as they are under the amended Quebec Privacy Act. For example, consent, what I happen to have on the screen. So to take a step back, the principle of privacy, personal information in this country is that if you want to collect, use, and disclose, that's the traditional phrase that we use in the privacy biz. If you want to collect, use, and disclose personal information of an individual, you must get their consent. Period. There are a few minor, very minor exceptions in a few of the laws, okay? But you really generally, for the most part, must get the individual's consent. Under the
And that
GDPR, under the
that can't,
GDPR,
sorry,
go ahead, Simon.
I'm just going to say that can't be buried in a terms of use somewhere. You actually have to have affirmative consent.
Correct.
It's
For
important
that's,
to
I
make
mean,
that.
that's a much longer conversation about the
Yeah.
validity of implied consent versus express consent, which we're running out of time. I won't be able to do it. But the point being, the point I was trying to make, Kevin, I wanted to make, is that under the GDPR, there are other categories of ways which you are allowed to collect, use, and disclose personal information. Collect, use, and disclose is melded into one term called processing under the GDPR. But for example, if you have a contract with someone, you can process their personal information as part of that contract without their consent. So there are some differences between the GDPR and our law. But yes, certainly, to get back to your original point, those who are GDPR compliant are 90 to 95% of the way there, most likely. Okay?
Great.
There are some adjustments in the consent rules. I'm not going to get into the details of them. Okay. The most important thing to remember is probably 14, the third bullet point that you've got in front of you. Okay. The consent itself has to be clear, free, and informed, and given for a specific purpose. And that goes back to what's in section 12. You can only use personal information for the purpose for which it was collected. Okay, so if you get someone's email address to send them a newsletter, you can't start using that email, a specific newsletter for one particular company. You can't start using that email address to send them information about a completely different company, for example. Also, for the first time, because PROPETA doesn't have this, we have very specific rules about minors, and you cannot get consent from a minor under 14. You have to get it from their parent or guardian, what's called parental authority here in Quebec. Okay. Still more coming into effect this coming September. Okay. We have a sort of a right to be forgotten, like they have under the GDPR. It's called a right to de-indexation. Basically, if you have a link to someone's personal information or a link to a site that has personal information about somebody, you have and they ask you to de-index it, you have to. A lot of conditions and factors, but no time to go over those. Now, this one, the next two are really important for your business. Okay. And so let's take a look at them, because the basic principle, and this was sort of there previously, but it is there now, very explicitly. If you've collected personal information and you have used it for the purposes for which you collected it, and you are done with that purpose, you must then either destroy it or anonymize it. Okay? Now, technically minded people out there will probably agree with me that true anonymization is probably impossible these days. But there are some phrases in the law that tell you, well, use best practices, and they define anonymization as irreversibly no longer allowing a person to be identified. It's probably impossible, but suffice it to say, do the best you can, and certainly anonymize it. Don't keep that personal information longer than you have to complete the purpose for which it was collected. Another very important thing, once you are transferring personal information to a third-party service provider, it is now going to be the law in Quebec that you have to sign a written agreement about how that personal information is going to be treated and how all the details of it and who is responsible for what, et cetera, et cetera, et cetera. Now, and back to Kevin's point, those of you who are GDPR compliant will know all about such written agreements, and you call them DPAs, data processing agreements or data processing addenda. We use them both interchangeably. We call them DPAs. And they're not called DPAs in the Quebec law, but believe me, we're all going to call them DPAs here in Quebec. Okay? And they are now going to be required just anytime you're in Quebec, you're sending your personal information to a data center in Toronto, or even a data center in Montreal for that matter. It doesn't even have to leave the border. Okay? It's a third party that is getting personal information that you collected. You're going to have to get a DPA in place with that third party service provider. Now, why do you care about adhering to the law as amended? Well, you care because these penalties are massive. Okay? Used to be the penalties under the law and the penalties as they currently are under federal law were nothing. We saw in the GDPR how we got these giant amounts. Well, we have going to have the giant amounts here in Quebec as well. The biggest one being the greater of 25 million or 4% annual turnover, which can even be doubled. And not only is the enterprise, to use the language of the Quebec law, the company liable as a company, individuals in the company, if they authorize an act that was in violation of the law, can be held liable under Section 93. So there is a sort of a three-part regime to the enforcement mechanism. Okay? Penal offenses, which the Commission d'accès de l'information will take you to court, and the court will implement a fine. Administrative monetary penalties, which is the traditional term, AMPs, although if you read the Quebec Act in English, it says monetary administrative penalties, but we're all still calling them AMPs anyway. Those are administered directly by the Commission d'accès de l'information, or as the language of the law says, a person who they may so designate. And then the private right of action, what that means is individuals can take you to court. So the penal offenses is when the Commission d'accès de l'information can take you to court. Private right of action means individuals who have suffered as a result of the bad things you did with their personal information. They can take you to court. So a three-headed monster of enforcement mechanism. And this table sort of summarizes, where you can get what sort of penalties based on what violation was there. And before I forget, I'd like to thank I believe Bordner Ladner Gervais, who I stole this table from, one of their doctors. But they would allow it because I know them very well. So take a good look at this table. Remember it. Remember those numbers down at the bottom. The 25 million, the 10 million, and individuals who can take you to court. And that is why you're going to want to adhere to the law. The last thing, Yeah,
When does the private right of action actually, is that next year? I mean, I know that was integrated into Castle and it never really came
yeah,
into
it never
existence.
came under
Yeah,
Castle. It never came into effect
yeah,
in the Quebec law this September 22nd.
okay.
You could be sued on September 22nd. Next year, this is all that's left of the law to be put into force. If someone asks you for their personal information, you have to tell them you have it. You have to tell them what it is, and you have to give it to them in some sort of format that they can take. And that is literally all that's left to be implemented next year. So as you can see, just about everything important comes into effect this September. That brings me to the end of my presentation. And I already see there are some questions in the chat. So let me take a look at those. If there are additional questions, please submit them now. Frank Einstein. Yes, email addresses are personal information. And he came in late, but personal information is a very broad category. It can in anything that identifies an individual or in combination with other information can identify an individual. And as they mention, tracking pixels, yes. And other, I keep mentioning, we mentioned pixels, we mentioned IP addresses, but technical people know there's other identifiers as well. You know, web beacons, there's other forms of technology that have some sort of tracking feature that can be, used to track individuals. And with that information being combined with other information, you could, in theory, identify an individual. Thus, it would count as personal information.
With
Not
regard to email marketing, I mean, a lot of our clients use forms, so you can have as many fields in that form as you want. Is it a good rule of thumb to limit the information that you are asking of people when they do sign up, or is it just you have information, yes or no, it's black and white, and
yeah. I mean, look, it's you kind of have to look at it case by case, and take a step back. Um, you know, I didn't want to give sort of a lesson in best privacy practices, but one of the important elements that's in the law that's it's much reinforced in the current law, but it's been around forever, is that you should only be collecting the personal information that you absolutely need to serve the purpose for which you collect it. So even though, so to take a very basic example, Kevin, you want people to sign up for your newsletter. Okay, forgetting the Castle implications or whatever. Let's just talk about the privacy implications. What do you need for someone's newsletter? Okay, you need their email address, certainly. Maybe you want their first or last name to put in the, Dear Alan field. Okay. You don't need their phone number to send them a newsletter. Now, you may want that phone number. You may want their postal code, to find out what kind of area of town they live in to better market them to you. Is that really required? You need to ask yourself to send them a newsletter. Okay. So, always, it's here where the business part and the law parts clash tremendously. Okay. And I always joke to some of my clients, because I actually have an MBA and I worked as a marketing executive for 4 years, and then as a part-time marketing executive for another 4 years. I understand the need to have all the information necessary for marketing purposes. The more information you have, the better targeted your marketing is. But from the privacy standpoint, from the collection of personal information standpoint, that's bad, right? It's literally the opposite. It's where the two sides of my brain clash. And I often have to tell my clients, I'm sorry, the lawyer side of my brain wins out because you've hired me as your lawyer. So I understand that you want all of that information and you want to fill out, you want to have a form powered by CakeMail that collects all this information, but it may not be the best idea because you may be violating, these privacy laws that state very specifically only collect the information you absolutely need for the purpose for which it was collected. Still, excuse me, I'm just reading this question. Donc, je répète la question, c'est en français. Il y a beaucoup d'outils pour aviser l'utilisation des cookies sur un site. Sont-ils déjà disponibles, valables pour les sites canadiens et québécois? Devons-nous utiliser un outil pour le GDPR, RGPD entre-temps? This is a very good question. And look, there are a million plugins that handle that. And Pierre, je m'excuse, je vais juste traduire un petit peu la question pour ceux qui n'ont pas compris qu'est-ce que j'avais dit en français. The questioner was asking, do we need to use those cookie banners? Do we have to have those cookie banners that you see when you go to websites? I accept cookies. To continue on, please accept cookies. And Pierre is asking, are those available in Quebec and Canada, or should we be using the ones for GDPR? Et ce que je peux vous dire, Pierre, c'est absolument ce qu'ils ont développé récemment, ce que j'avais vu dans plusieurs des plugins, surtout les plugins plus connus. Vous êtes certain, il dit certainement, tu peux cocher cette boîte pour que ça soit valable avec les lois américaines, avec les lois canadiennes, avec les lois du GDPR, d'Europe. Cependant, sont presque tout pareils. La raison d'avoir cette boîte pour ce cookie banner, c'est qu'un individu accepte de recevoir des cookies, des témoins sur leur ordinateur. Le principe de base, c'est absolument le même sous le RGPD, sous la loi québécoise, et s'il y en a besoin sous PPEDA, mais moi, sous PPEDA, à mon avis, on n'a pas besoin. Donc, cependant, le principe de base, même si on utilise un cookie banner du GDPR, ça serait valable au Québec. Parce que c'est l'importance, c'est de dire à quelqu'un, acceptez-vous qu'on met des cookies, vous reconnaissez que nous utilisons des cookies, vous acceptez ou vous refusez cependant, c'est toujours pour avoir ce choix, et avoir un lien à la politique de vie privée où on explique tous les cookies qu'on utilise. Et tout ce que je viens de dire, c'est le même processus que ce soit au Québec, que ce soit en Europe. Donc, un logiciel qui fait un cookie banner pour le GDPR, certainement, ça marcherait pour au Québec. I see we are running very low on time. Kevin, you got any question for me? You'd like to? I can give a 1 minute answer to
one
before we
in
end.
the
Sorry,
chat.
Alan, I have two things here on my side, Alan. One is
Okay.
interesting. It's about the nonprofit, because we know that sometimes the nonprofit organizations, they don't have to comply the same way as the business organization. So is this law applied to nonprofit organizations? Is it the same for them?
No, generally not. There are some exceptions for certain type of nonprofit organizations, but if you go back, and I can go, if I can perhaps go back very quickly. If you look at the application, as I had up here, the Section 1 application, okay, it speaks of carrying on an enterprise. Okay, the law applies to companies and who are defined as an enterprise. An enterprise is defined in the Civil Code of Quebec as any group that is involved in an organized economic activity. So generally, most nonprofits would not fall into that category of an organized economic activity until a nonprofit, for example, starts selling merchandise to raise money for their organization. That selling of merchandise is an organized economic activity and most likely would be covered. So the general activities of the nonprofit, most likely not, but as soon as they start doing some sort of organized economic activity, even if by the strict reading of the law, they would not necessarily have to comply, they absolutely should comply. And again, this is something that's going to be interpreted by a court 5 years from now. So better safe than sorry, let's say.
I have
Yeah.
also a couple of questions that if you can just review, it would like review the whole process. People are asking, if Cake Mail is hosting my client's data, who's responsible for the data? So I think the idea of reviewing the level of responsibility for each one would, like, I think, summarize the whole presentation, if it's possible for you.
Oof. Yeah, I'm not sure I could summarize the whole presentation. Put it this way, I don't want to speak for Cake Mail, first of all, but I'm sure Kevin will tell you that Cake Mail is doing everything it can to ensure its compliance with the law, and ensuring that its clients comply with the law. But again, I'm sure Cake Mail would also say that it's the responsibility of its individual clients to seek independent legal counsel to make sure they are complying with the law. So,
I'm sorry, but
No.
my question is maybe not precise. Is if I'm getting the data from my clients and then I'm putting them like on the software like Cake Mail. At the end, am I responsible for my
Yes.
data?
Yeah. Okay. My
Is the
apologies.
client?
Yes,
Sorry.
100%. 100%. As no matter, look, everyone is going to be responsible, right? If you touch individuals' personal information at any stage, okay, if you collect personal information, if you transfer it to someone else, that's someone else. If you collect personal information, even on behalf of someone else, but you're collecting it and you touched it, if it hit your computers in any way, shape, or form, okay, you are going to have responsibilities under this law. So even you can't escape liability by shifting roles over to some service provider. That's, I think that's what the question might be getting.
I mean, if you're using a provider that doesn't have the policies in place or practices in place, then obviously, yeah, you're collecting that personal information in the get-go. So, I mean, if you're not using reputable processes, that's a problem you need to look at. But I mean, you said this first, not to close out here, but you said privacy first. I think a lot of people need to move in that direction. That is what the Quebec government ultimately wants everyone to start their ideals, and they need to have policies in place. I mean, all of this makes sense. You need to have a director of privacy, somebody in charge in your company that is in charge of this. If there's a breach, you need to have a policy in place to make sure, to report that properly. So, I mean, all of this makes sense. This privacy law is not meant to stifle business in Quebec. It's meant to protect its citizens. So at the end of the day, you need to put your frame of mind accordingly and follow that, to the letter. I mean, it makes sense.
I think that's it. I could not have said that better myself, Kev. I think you should be a lawyer.
Missed my calling. Alan, I really want to thank you for being here today. It was a lot to cover. There probably could be another webinar on this, but again, thank you very much for attending today and for all of your knowledge. And being my friend. And we'll talk soon.